Good evening, everyone, and a very warm welcome to Farmers Weekly's Diversification webinar. I'm Susie Horn, Farmers Weekly's business editor. I grew up on farms in East Yorkshire and North Yorkshire. Both my brothers are farming arable and sheep, and one of them also has diversified enterprises, clay pigeon shooting, and a food and drinks business. I've been working for Farmers Weekly most of my working life, and I'd just like to thank our panel tonight for their time and expertise. We're in very good hands. They've got lots of experience in advising on diversified businesses and many of the issues relating to running them. We're going to be concentrating on planning advice, legal issues in relation to diversification, and insurance. So to introduce our panel members, they're Nicola Quick, an associate in the rural team at Carter Jonas, Jonathan Thompson, senior associate in the agriculture team at law firm Thrings, and Freddie Braithwaite Exley, an account executive with Aplan Rural Insurance. I ought to mention also that Jonathan will be covering English and Welsh legal advice only. Nicola's planning advice will be with relevance to the planning system in England. Freddie will insure anything within reason, so that it won't matter whether you're England, Wales or Scotland for his answers to the questions. Each of our panel members is going to make a short presentation, and then we'll open things up for discussion and take some of the questions that we've already received and the ones that come in during the webinar. Please ask questions anytime by typing them into the box at the foot of your screen, and then I can direct them to the relevant panel members. And please don't hold back with the questions, any subject, and we'll answer it if we can. The webinar is expected to last for about an hour, perhaps a little bit longer, and afterwards it will be available on demand, and you'll get an email to let you know when the recording is available. So let's go straight to our first speaker, Nicola Quick from Carter Jonas. Nicola, thank you.
Thank you, Susie. So I am an associate at Carter Jonas, and giving a little bit of background on Carter Jonas, we are part of a collaborative property consultancy network providing a wide range of property-related services. The countries that we operate in are predominantly England and Wales, as Susie has mentioned, but we do also cover Scotland, Ireland, Germany, and the Netherlands. We have teams covering a variety of areas, but just to name a few, we have a rural leisure team, planning and development, commercial, energy, minerals and waste management, and infrastructures. And there are many more as well. In terms of my area of cover, I'm based out of our Taunton office in Somerset, and at the moment I have planning applications in Cotswolds District Council, Wiltshire County Council, and down as far as Cornwall Council. Next slide, please. So, diversification. I actually looked this up in the Oxford Dictionary, and it's defined as to enlarge or vary its range of services, products, or field of operation. Therefore, it's very broad-ranging. So in terms of my planning talk, I'm going to have to keep it very generalised, because not only, as the slide shows, there's a huge variety of things that come under diversification, but also it's going to affect where you're located, because we have the National Planning Policy Framework that overrides the whole country. But when you go down to your local district councils or county councils, you have your own local plans and policies in that area. So, as I've already mentioned, diversification opportunities, there are many across farms and estates, and not all of them do require planning permission. So that's always a good starting point. The types of opportunities available to you will depend on your own market research and the assets that you have available. So to give a bit of an insight, I've got a list of current projects that I'm currently involved in, just to give a bit of a flavour. So one is a dog training secure field. Now this unfortunately has been perceived by other applications locally that people think that you don't need planning permission for a dog secure field. And unfortunately you do, because it's an agricultural use initially, and obviously you're looking to change that use of that field to dog secure training. Also a farm shop and cafe, and one slightly similar to that, expanding an existing pick your own business by erecting a further building to make it larger. converting traditional buildings into holiday lets, and also the change of use of a chicken shed into caravan storage, which actually lent itself very well. Next slide, please. Moving on to my planning permission top tips. I would always encourage everybody to undertake pre-planning consultation. Now, that's not only with your local authority through a pre-application inquiry, but also engaging with your parish council and your neighbours and local community. Which leads me into the second bullet point, the story, is to get them to understand what you're proposing and why you're wanting to do this project. Everybody likes, unfortunately, to be a little bit nosy, and also just to understand exactly what you're looking to achieve. And big bonus points are always environmental and sustainable credentials of any application. Moving on to the practicalities. I've listed a few, but this list could be a lot longer, and I'll just highlight a few of them. So initially, highways. This is looking at, for example, access and therefore visibility. Most country lanes are 60 miles per hour, but actually if you were doing 60 miles per hour, you'd probably be in your neighbour's field. So actually you'd need to look to potentially do a speed survey to show that actually it would only be reasonable to do 40 miles per hour on that road, and therefore the visibility space could be reduced to reflect that, but you would need a speed survey to justify it. But also you would need to look at the parking requirements, how bin lorries are going to come in to take waste away and things like that. Moving on to services. Services are quite often a cost if they're not already in site or on site, sorry. So you'd need to have an understanding of what that cost is going to be, and that would lead you into the viability of the entire project to ensure that actually the cost of getting services in aren't disproportionately high. And then ecology is always becoming a bigger and bigger thing. Here in Somerset, we've got a phosphates problem, so that's leading to delayed applications. But there's also the traditional, for example, bat and barn owl surveys that would be required on a traditional building if it was going to be converted. Now, your emergent surveys, that are your traditional dawn and dusk surveys, they could only be undertaken between May and September. So we're right at the end of that window now, and I suspect you'd be unlikely to find someone now to do those surveys. So you'd be looking to wait until next May to get those surveys undertaken. So it's just a timing thing to look at. And then I've listed a few more down through, and there would be more practicalities depending on your particular application. Second last, visual illustrations. With part of an application, it's likely that elevational drawings will be required on any building, and often they don't give the wider picture in terms of the landscape. So how does that building actually fit within the wider context and the scale and things like that? So I would always recommend trying to get some visual illustrations coloured up so that you're able to clearly show what it's going to look like, because unfortunately some elevational drawings are quite hard to understand. And then leading into specialist advice. This is not only just on planning, but also, for example, the legal status, who owns the land to make the application, in terms of taxation, ensuring that whoever owns it, you're not going to cause yourself a taxation problem down the line. And obviously the practicality side that I talked about earlier, for example, if you're going to be proposing a diversification project that creates a lot of traffic, it's likely you're going to need a highway report by a specialist in order to explain how those movements are going to take place. So I'll now hand back to Susie for the next person.
Thank you very much, Nicola. We probably could do a whole webinar just on planning easily, and probably the same with some of the areas that Jonathan's going to cover. So I'll hand over now to Jonathan for some legal tips on diversification.
Thank you very much, Susie, and good afternoon to you all. I've been an agricultural property lawyer for 22 years. I'm now at Thrings, as Susie said, but it's given me a 22-year view of diversification, from when diversification was encouraged, but on the fringes of businesses, of rural businesses, to now being a potential mainstay of agricultural businesses in a post-Brexit and post-COVID world, hopefully. My particular interest was flagged with a client a few years ago when I was working for a firm in East Anglia. And it was a client who otherwise spent his time in the House of Lords, which is quite amusing for reasons I'll come to, in that he started selling veg by the road. So I have an image of this peer and one of his staff literally with a wheelbarrow by the side of the road, just selling veg. And that grew into an award-winning shop that brought up all sorts of issues in terms of diversification. Now, the introduction to this webinar stated that diversification was about planning, and more planning. And that is a really good summary. And so what are my top tips? So my core areas, I've got 3 core areas, and they're under risk, regulation, and reward. Now look at these in turn and topics come out of those. So first, risk and regulation. Now, being a lawyer is about advising on commercial issues and risk, using the framework of law, as Susie said in my case, in England and Wales, as a structure. Now, law and property ownership and the ability to occupy property in a variety of ways give a rigid backbone to a stable economy. And sadly, we can look elsewhere on the planet, for example, countries without that backbone, for example, sadly, Afghanistan at the moment, where if you don't have those core things in place, an economy can't function, both rural and urban. So my role, though, is I don't comment on the commercial gain. I comment on aspects of it, but I look at what can assist and enable or limit the reward, the ultimate game, the game and gain for doing the diversification project. So some risk and regulation topics. First of all, can that diversification be done in terms of land use? Are there either freehold restrictive covenants, or if you're a tenant, covenants in the lease that restrict the use? It might be able to be done practically, but is there going to be a breach of some legal provision if diversification projects actually carried out? And if that's the case, is there someone there that can enforce their objection? As Nicola mentioned, is planning permission needed for a change of use? Is there some form of agricultural tie or user restriction on the land? If you're a tenant, does the user clause in your lease allow the change of use? Are you going to have to get landlord's consent? And whether you're under an Agricultural Holdings Act tenancy or a farmer's tenancy, there are processes to follow to do that. Now, as I deal more and more with these diversification projects, and particularly given the changes under the Agriculture Act 2020 and the impending and exciting Environment Act in the autumn, I query whether diversification will be deemed as a standard agricultural use in the future. Who knows, but that could well be sorted out in one way or fashion in the future, whether that's going to be just people agreeing to do that or it comes to a court case, who knows. So the next thing I think about is, how is the diversification project to be placed on the land? What is the land use now? What is the land use in the future? Whose land is it? If you own the land on which the business is sited, then you've only got yourself to think about, and that makes it a lot easier. But if you're letting land, if you're going to lease land to someone, how's that going to be regulated? It's probably going to be currently a business lease under the Landlord and Tenant Act 1954, which gives rights to certain tenants to stay there. You'll need to agree terms between the landlord and tenant. And as a landlord, you're going to want the tenant to comply with statutory obligations affecting the business and the site. Terms of the lease, like any other lease, you need to think about whether there's going to be a break clause, in this case, if the venture fails. Rent review, the length of the lease, services, service charge. There's an awful lot to think about. But principally for a landowner, they're going to want to avoid a liability for problems and accidents. And that partly harks to what Freddie's going to say. Now, if you're taking the risk commercially, you want the reward. So if there's a landlord and tenant situation, from a landlord's perspective, the tenant's getting the reward, you want the risk on the tenant. Access is also another issue I come across more and more. I've got a matter at the moment whereby there is a dispute between 2 adjoining landowners because one has access rights over an adjoining owner's land for agricultural purposes. Now, query whether that allows use for a diversification business. And I've got more and more of these matters coming across my desk at the moment. Then if you're a landowner, does the project fit with your brand and vision for your business? This is something I push more and more with clients at the moment. And we see more and more with the post-COVID working, how there is a lot of reliance and happiness about how the farm gate brands have developed. So everyone has a brand, and that's something to think about. Could there be a joint venture between the parties who are currently landlord and tenant? So you could lose that relationship, and those perhaps becoming more and more old phrases and ideology, and become business partners, joint partners in the venture. Another thing to think about is the fact that the project could also be a useful family succession trigger discussion. It's always difficult to have that discussions, and sometimes you just need that trigger to start that discussion, and you can perhaps kill two birds with one stone here: diversification and family succession. If you're a tenant, it might be an opportunity to change the terms of your occupation of the landlord, and a rent mechanism, especially under a farmer's tenancy, could be changed. We also need to think about events, risks and managements on site. Whose responsibility will that be? Employment issues. If you're starting to employ people, they're going to think about their employment contracts. The place to possibly outsource your human resources obligations, not obligations, but requirements. The obligations will be on you as the employer. Intellectual property rights also come into it. I had a matter with a client whose name was on a quite good brand of beer, and it became an intellectual property rights issue. Again, it's not something I deal with. Is my sort of standard everyday toolbox is property law, but into that comes into it. Is there a shop involved on site? You then got to think about food produce, liability, and trading standards issues, both commercial and civil. Insurance to occupiers, that's obviously an issue to be dealt with in the lease, but also by Freddie. If you're going to sell alcohol, you're going to have a liquor license to think about. And children as well. If you're doing a business, a diversification business, ecotourism, their children, you may well have safeguarding issues to think about. Not something I ever thought I'd have to think about when I became an agricultural property lawyer, but it's something that has come up. And I've certainly got some clients who are doing ecotourism and having scouts come on their sites, and it's something that's got to be seriously considered by them. Drainage and water is another issue I had in the last few weeks, where I had a client refuse a site license from local authority as the pollutions didn't have a hot water supply. Something as simple and practical as that can stop a whole project in its steps. And so now to reward. If there's a joint venture, how will it be shaped? Will it be a good old-fashioned partnership? Will it be a limited liability partnership? Will you be incorporated, become a company? Is it a new business? How is the income to be managed and shared if there are joint business owners? Is there equality in the payback relative to all the money and time investment of all the partners? And as Nicola mentioned, tax is also an issue, both in terms of income tax, how will that income be treated? And then also in long-term capital gains tax, and particularly inheritance tax planning. Will a change of business use to a non-agricultural use affect your inheritance tax agricultural property relief planning? Now, there's an awful lot to think about, and particularly with the changes coming with the Agriculture Act and ELMS and the Environment Bill, diversification is going to take many, many different shapes and forms. And that's what makes it actually the most exciting time to be in my profession in my 22 years so far. So in summary, I'd say is think about what you're doing, take advice on your risk and the regulations so that the reward is right for you. So I'll now hand you back to Susie.
Thank you, Jonathan. Again, as you said, lots to think about. And we had a feature in Farmers Weekly recently looking at the tax aspects of diversification. And one thing that might not be obvious to someone is that you might create a very successful diversification and then while that operation might be valuable and increase your profit and turnover, it could actually devalue some of the other assets, and that's perhaps not something that people would think of. Anyway, we might cover some of that in the questions. So I will move on to ask Freddie now to do his 5 to 7 minutes, and then we'll open the discussion and the questions. Thanks, Freddie.
Thank you, Susie. Yes, insurance, everyone's favourite topic, or certainly mine anyway. But good afternoon, everyone. My name's Freddie Braithwaite-Aixley. I work as part of the A-Plan rural team, delivering farm insurance for farmers little and large, actually across the country. And between us, as Susie said earlier, we're able to do England, Scotland, and Wales. I've been a broker for a good few years now, but I actually had a former career as a land agent, and in doing so, I was involved in buying insurance from the client side too. So I've been involved in both sides of the insurance transaction. And what I wanted to do with the few minutes I have now, before we get stuck into some questions, is give you a couple of reminders of what would have been really useful to really know then as a land agent that I now am fully aware of now, and link that to diversification and what you should be mindful of in all the projects you're thinking of or perhaps are already doing. And the first is what diversification means to an insurer. And Jonathan and Nicola have both touched on how wonderfully expansive it is and how complicated it could be. But it's been a buzzword ever since I've been involved in the rural world, and diversification. I'm sure it will continue to be of great importance to most rural businesses. And I've seen all these weird and wonderful ways come forward through both lines of work that I've done. But to an insurer, diversification is change, and that's it. It's anything you do different to the way to what you've been doing currently is change, and an insurer needs to be kept in the loop as to what that is. Not because they want to waste your time or send you more paperwork or charge you more premium, but it's because even the smallest of changes in what you're doing can expose you to quite significant risk. And in order to highlight, I wanted to take a look at a couple of examples, and I've seen in some of the questions already popping up that change of use is quite a common theme, whether that be from a farm building to let storage, or perhaps to office space, or even a holiday let. And what I wanted to do is pose a few hypothetical questions, get your questions flowing, and potentially not give you the answer to them just yet, but hopefully it will prompt you to ask some of them further on. But it will get you thinking in the right way anyway to start off with. So first, in a diversification project, in a conversion for a change of use, has there been any building work? Are you covered for the construction phase of it? Who should be responsible for that phase? Is it you, or is it the contractor? Have you checked the contractor's own insurances themselves? Assuming there has been some work to the property, have you changed its value? Have you changed its sum insured? Have you refurbished it, added contents? Would it cost you more to replace it now, having completed the project, than it would have done before? Are you now generating an income from the building? I hope so, because that would be the purpose of diversification, you'd have thought. But do you want to protect that income? And if so, how long do you want to protect it for? If it's a holiday let, you might be able to replace the building in 12 months, but would you be able to build up that client base of repeat tenants and repeat guests in just 12 months, or might you need 24 months or even 3 years? Those are all things to consider. Is it still your responsibility to insure the project, or have you passed that on by way of a tenancy agreement? Further than that, are you providing a service? Water, electricity, heating? And if that service fails to your tenant or to the business that you're letting it to, and they can't function, are you responsible then for their loss of income? These are all things to be mindful of, and usually with these larger projects that like change of use, because they are just that, larger projects, they tend to be well planned and thought out, and often insurance forms part of that conversation in the planning stage. But it applies also to the smaller stuff, the stuff you might just do with less consideration or just get on and it happens, like working on someone else's farm. Maybe you're moving kit or spraying a field, or drying someone's grain for them for goodwill. Are you covered if you damage their property in doing so, or damage their crops? Are you changing that risk? Similarly, adding solar panels to a farm building roof, or insulating a farm building, for example. Do you do DIY livery, and maybe occasionally you help out and ride some of the horses, or give them a lesson here and there? As I say, in all of these, are you changing the risk? And that's what you really need to be careful of, that actually by developing and diversifying, small or large scale, you can change this risk by even the smallest changes. Now, I have said all this not to worry you, but to remind you really of my second piece of advice, which is that the insurance broker works for you. I think it's sometimes forgotten, actually, that we're not just here to sell you something. We're here to give you guidance and be your broker. And we're always acting with your best intentions. We're not only there to find you the right cover or give you the right price, but it's We're there to give you a guide on what cover potentially is available out there. And it's often what differentiates a good broker from a great broker is that advice and that confidence they're able to give you. So whenever you're thinking about these projects, and just before you get started on them, preferably, pick up the phone to us, email us, or arrange a Zoom meeting like we do these days, or actually we can come out and see you in purpose and involve us in the conversation, no matter how large or small, weird or wacky it might be. Because in theory, once you put it on our desk, it becomes our responsibility, I suppose, within reason, that is. I'd like to let holiday tenants use my swimming pool. I'd like to sell homemade jam from the shed. Create an activity farm. Maybe you're thinking of adding tigers to it, I don't know, but maybe not. Whatever the question might be, we'll do our best to explore the options available and talk them through with you and find out what cover is available and perhaps isn't available. And in doing so, we might just be able to help with the decision-making process and give you a bit of peace of mind in all these diversification projects that you might have in mind or are already doing. But that is my 5 or 6 minutes now before we get stuck into some questions.
Right, thank you very much, Freddie. Again, lots to think about. I just actually a question to Freddie, just first of all. Public liability is obviously a big issue, and it depends on what your diversification is as to how much you should cover in terms of that liability. Would you like to just mention that quickly?
Yeah, sure. So I'll just get myself off mute there for a second. God, can I have another 10 minutes maybe? It's a huge topic, and it's a really pertinent one, actually, because liability levels have, the recommended amount has changed a huge amount in the last few years. Essentially, it stems back to something called the Ogden rates. And the Ogden rates were used or are used still to calculate personal injury and fatal accident claims. And the idea is that it puts them back in a position or is able to support someone through their life after such an incident. And what happened when they changed these back 3 or 4 years ago, so say 2017, is the compensation that was paid out in a public liability claim or an employer's liability claim increased drastically. And I'm saying drastically, to give you a basic example of what happened initially was a claim. There was a claim, a 7-year-old in a car accident. The claim at the time when it happened pre-change was 13 million, and post-change was 24 million. Same claim, just a different rate of calculating it, and that was the difference in what was the payout would have been had it happened now. And what we've found is that even when I started land agent, standard cover would be about 5 million for public liability and employer's liability, and you're legally required to have employer's liability at 5 million. But most people now have moved to 10 million, which is great. But actually, it's in my opinion, you should be really thinking about whether 15 million or 20 million is worth your while as well. And that thought process comes down to what you've got going on the farm. If you've got lots of young children coming onto a farm doing slightly more high risk activities, or is it all still slightly more straightforward, not as many people, not as much risk? And that's a great conversation to have with your broker, but it's certainly something to be really mindful of is, has my public liability and my employment liability limit increased enough or moved with the times through these changes in the compensation rates?
Okay, that's great. Thank you very much, Freddie. So we'll go to one of the many questions that we've had submitted, some of them in advance and some while the webinar's been live. And the first one is, I think if we go to Jonathan on this one first, what pitfalls should I look out for when inviting the public onto my small holding to do goat walking experiences and supply afternoon teas? This person also is thinking of doing animal care courses, craft days, workshops in making products from goat's milk, and cheese making courses. I think it'll come back to an insurance aspect as well. But perhaps if we go to Jonathan first, what sort of alarm bells or advice does that give rise to from you, Jonathan?
Well, the first thing is, it sounds a great idea. Do it. Sounds very entertaining as a sort of father of young children. But in terms of sort of legal side, it harks back to some advice I gave to a client recently about signage. and just telling people, yes, you're coming on here, it's a learning experience, but where these are the pitfalls. It really is about, it does come back to Freddie in a way, it is, or a similarity between us both, it's about managing the risk, managing people's expectations about what that risk is. And then in terms of the sort of the food side, again, it's making sure that there's going to be if there's any problems in relation to consumption of food, that you cover for that, but also making sure you've got the right licenses on site. This isn't particularly my area or my area at all, really, but I'm just thinking about food standards, food safety, and the Food Standards Agency, something you probably need to look at.
I can jump in and say a couple of words if you'd like me to there. Susie, can't hear you.
Sorry, then if you come in briefly, Freddie, and then we'll ask Nicola if there are any planning alarm bells ringing on that one. Thank you.
Sure. I mean, the first thing I think about any of these projects is, does your insurer know about it yet? Because without knowing about it, then you really are opening yourself up to trouble. But provided you let them know about it, it's in their court to tell you whether they're happy to cover it or not. And I think as a general view of insurers, diversification is not a new thing to them. They're quite happy to understand that farms are moving away from just the traditional farming movements, and therefore are willing to consider these slightly out there ideas. And part of it is just explaining the risk to them. What do you want to do? I want to have groups of children coming through. They're going to be guided, or they're not going to be guided. I'm going to sell products, and therefore, does your product liability cover you in that element? It comes back to that conversation. Involve them in the conversation, and your broker can work it through with you and say, we can cover you for this. We'll make sure you're covered for that. Actually, it's probably not a great idea to leave them alone. We can't cover you for that. And 9 times out of 10, all they're really after is a risk assessment for you to say, I've checked that there is a risk. This is the risk I believe there is, and this is what I've done to mitigate it.
Great. Thank you, Freddie. And Nicola, any planning thoughts on that one?
Thanks, Susie. So the parts where the animals are still going to be grazing ground and all the rest of it, you're remaining agriculture, but it's the parts that are going to be changing more into a leisure use that will require planning permission. So, for example, the paths that you're going to be taking round, if you're doing it throughout the year, you're going to need to make sure you have the planning permission to allow for those visitors to come, and also have the parking facilities for them, and also what buildings you're going to be using for the afternoon teas or the craft days and things like that. I assume that's going to be in some form of facility, and that will be requiring planning permission. Obviously, the parts where animals are grazing the ground, that's not going to be changing use in terms of agricultural, but it's the other elements that are around it.
Yeah, okay, thank you very much. So we've got one that's, although we haven't got an accountant, I know Jonathan's happy to cover tax in some aspects and did touch on the inheritance tax possible relief implications in his presentation. We've got a question which is, does diversification mean moving away from agriculture and any tax treatment associated with agriculture? So Jonathan, perhaps you can elaborate on some of your very brief warning in your presentation.
Yeah, sure, Susie. I mean, well, what a fascinating question. I mean, I think the core of it comes to what is the diversification project going on. So if it is clearly a change of use because you are taking a piece of bare land and you're building something on it, and you're either going to let it out or use it for something that's completely not agricultural, then you're clearly going to lose that potential of agricultural property relief. But then potentially, if it's a building that's going to have some sort of quasi-agricultural use, there could be an argument there. Conversely, if you're doing a diversification project in relation to, for example, an elm scheme and the Environment Act, then potentially that's still agricultural. So it really is wholly subjective, and there are a range of tests which the accountants and the in my profession, the tax and trust advisors could advise you more on. Susie.
Okay, thank you. Yes, I think with the lack of information about the tax treatment of some of the things that are going to be part of agricultural policy or environmental policy, within the next few years it's quite a problem for people, because they can't plan, because it's not clear about what will be deemed agriculture and what won't in some of the things that are to come. Right, we'll go to another question. Bear with me. How do I go about renting out redundant farm buildings to local businesses in the area? Do I need any special permissions, formal arrangements, etc.? I think probably that's probably one that all three of you would need to comment on briefly, but Nicola, if we go to you first, I guess it's change of use and that sort of thing. Yeah.
Thank you, Susie. So yeah, it will depend on what local business you're looking to go to, because you'll need the relevant planning permission. So if, for example, you're looking to go to storage, you'd need to be looking down that route rather than offices, for example. So it's either kind of two rules of thought, I suppose. You either go out and find the business that you want to rent the building and then get the change of use for that relevant building, or you decide what use you want it to go to and then go and get the relevant planning permission for that and then advertise it with that consent. And it will depend on, they will touch on Jonathan's bit in a minute, but it will depend on what use you're going for to what's the right arrangement for that. Because if you're going to keep it in agricultural storage, then it wouldn't need planning permission to change from agriculture, but I'm assuming we're going to be going for a change of use, and it's whether you go down your permitted development rights. So for example, you've got your Class R permitted development rights allowing agricultural buildings to a flexible commercial use, or whether you're going down full planning policy to convert them or change the use under that basis. I'll hand over to Jonathan.
Yeah, and that's a very good point. There is that interplay, and it becomes quite complicated and sophisticated between the surveyors and planning consultants and advice to the tax people as to what exactly is going on here. So I think that's a very good point, Nicola. Thank you.
Okay, and Freddie, and just any quick observations on renting out buildings to local businesses?
No, the only point I would make is if it's redundant before, you're likely to have quite limited covers for them. In the first instance, whilst they're redundant, you might just only have fire damage. But if you then convert them and upgrade them, you're probably likely to be wanting to add in additional covers like storm and flood and maybe subsidence and accidental damage. So worth considering what covers you have before and after the project.
Okay, thank you.
Actually, Susie, can I just come back on a point there?
Yes.
Which is, in terms of letting it out, it very much depends on the use. I've had all sorts of interesting matters where there are people letting out buildings for grain storage. Query, is it a business use? Is it an agricultural use? On the whole, if it is not agriculture, it's going to be a business use, and it's going to come to Part 2 of the Landlord and Tenant Act 1954, and will be a business tenancy, and there are certain rules in relation to that. Again, it very much depends on what it's going to be used for. In terms of special permissions, if you're a tenant already and you're wanting to sublet, you'll need your landlord's consent as well, and also potentially make sure there's no prohibition against assignment in your current tenancy. And that becomes very relevant to tenants under particularly Agricultural Holdings Act, where there's those long-term tenancies. Susie.
Okay, thank you. Planning question for Nicola. Do I need planning permission for pods or shepherd's huts? And I guess that's going to depend to some extent what type of land you're on, in terms of whether it's got any special designations as well.
Yeah, so it's always a really interesting one because everyone has this preconceived concept of, oh, because it's mobile, I don't need planning permission. And unfortunately, you may need planning permission. So starting off in the first instance is if you're planning to have it as a private or personal use within the curtilage of your residential dwelling, so for example in the garden, and you're going to use your shepherd's hut as ancillary to your house, so a summer house, or an extra bedroom when you've got a guest staying, then it's unlikely you'll require planning permission when you're using it in conjunction with your farmhouse. So it's not somebody separate, but it's in conjunction with the use of your dwelling. However, on a diversification perspective, it's as likely that that shepherd's hut is going to be used for example, holiday let, and it may be on agricultural land, and therefore you're going to have a patio outside it and all the rest of it. And so all of that area would need to change use, because, for example, a mobile field shelter, everyone thinks that they don't require planning permission, and in some instances they don't, but it does need to be moved. And I believe it's every 6 weeks that it needs to be moved, whereas a shepherd's hut, you're likely to have it connected up to a sewage system, and therefore you're not going to be moving it, and it will, although it's mobile, it will stay in the same place all year round. So it is likely that planning permission would be required, and obviously it will depend on your specific designations and your local plans to whether that is supported in your local area.
Okay, that's great. Thank you very much, Nicola. Right, one about landlords' attitudes to diversification, something that Jonathan's already touched on in terms of knowing that you won't be in breach of the conditions in your tenancy. This is from a National Trust tenant who the landlords always quash their diversification plans. Do the panelists think that large landlords such as a National Trust will be more open to diversification opportunities in future? Probably just for Nicola and Jonathan, this one, I think. Nicola, would you like to go first on that one?
Yeah, that's fine. So with the introduction of ELMs, landlord and tenants are going to have to work together to generate sustainable new income streams moving forward. So I can't touch on the National Trust in particularly, but big in corporate companies and things are going to have to work with the tenants in order to look at how BPS is now coming away, how other income streams are going to booster the income that the business is generating.
Thank you. Jonathan.
Thank you, Susie. Nicola, absolutely quite right. Obviously, in that case, I'm not going to comment on what the National Trust does or doesn't do. I'm a National Trust member and we're supported, but equally, I'm out for land tenants as well. Nicola's quite right. There's going to have to be a change of mindset generally, both in terms of all institutional landlords, simply because of what's coming down the road with the Environment Act. It will actually be often for the benefit of institutional landowners as well, some of whom are building companies and other owners of areas of land in large-scale swathes, that they can benefit themselves in terms of what they do, but also benefit the planet in relation to what the Environment Act does. So I think this mindset is going to happen, both on a general level in relation to everyone, but equally certainly in our land or in our sort of agricultural context we're talking about now. Yes, they will have to think about this, particularly as the nature of agriculture changes, and with all the pressures in relation to what's happening with changes in trade since Brexit happened, and the need for different types of income. This is going to have to become more and more acceptable. Mm-hmm. Susie.
Yeah, the rent's got to be paid one way or another. Right, we have one from someone who has an existing tenant. I presume it's a workshop or commercial let. They've got an existing tenant wanting to take on more space. One building for storage, which is 80 square meters, the other as an office, which is 50 square meters. The facility adjoins the existing letting, and it's fairly basic: a new felted roof and a toilet facility, all clean and painted with new electrics. What health and safety regulations should the landlord consider? And they're also asking what sort of rent should they ask. I think that's probably without seeing the place and knowing a little bit more about the location, that's very difficult. But if Nicola, I don't know if you have a sort of ballpark figure in terms of commercial space on farms, perhaps you could give that, but if it's not your area, fair enough. So perhaps we go to all three of you, starting with Nicola, Jonathan, and then any insurance angles from Freddie on additional space.
Thanks, Susie. Yeah, I very much, without knowing the location, it's nearly impossible to give a rental figure because, for example, here in the Southwest, if you were to have a storage unit on Dartmoor, it's going to achieve a very different rent to if it was just on the outskirts of Exeter with direct connection onto the motorway. But some very broad figures, given what limited information we've got, you could be looking at between £3 and £6 a square foot for storage. But obviously, it's going to depend on location, what your access is like, and the type of building that it actually is, to what sort of storage you're going to be able to accommodate.
Thank you, Jonathan. I don't know whether it's really your area, but any sort of thoughts on health and safety angles on lettings like that? Yeah.
To my mind, it really comes down to sort of thinking about the campaigns run by organisations, including Farmers Weekly, about health and safety in the workplace. It's really sort of health and safety at work at 1974 issues, really. Nothing particularly special there, but obviously different bits of law come in depending on what's activities going on. If you're dealing with chemicals, then there are different aspects there that have to be considered. Susie.
Thank you. So we'll go to Freddie, and I know when we've covered diversification in the past, Freddie, in Farmers Weekly, we've had advice about, it's fair enough to get a tenant and everything to be shipshape and nice letting being offered, and you're happy with the tenant, but you still need to know what the tenant's going to be doing in that building to make sure that you're not opening yourself up to liabilities that you're not, perhaps wouldn't otherwise be aware of. I'm thinking of things like spraying cars and using gas bottles and that sort of thing, getting rid of waste. So it's perhaps something to consider in the lease in terms of those obligations. But Freddie, if you just, from your experience in perhaps of some claims in this type of area, you could just sort of sound a few warnings.
Susie, you've nailed it. Absolutely hit the nail on the head. It's about managing what the tenant is doing, understanding what they're doing before agreeing the tenancy, and then making sure that your own insurer is happy with it. The simple things to check are whether they've got their own insurance in place for their activities. You as the landlord don't want to be responsible for your tenant who might be doing something wildly dangerous or whatever it might be. But in terms of claims, to give you an example, 33% of our claims are fire related. So anything you can do to mitigate that fire risk is really, really helpful. And one of the really ones, if you talk about health and safety, harking back to my land agent days, one of the key ones is making sure you've got electrical inspections done. It's a question that always pops up on your statement of fact in insurance to say that actually all commercial buildings have got their electrical inspections done and up to date in that regard.
Thank you. Just on that claim, that 33% of claims being fire related, is that in the farming side of the business or in diversified farm businesses?
It's across the whole farming business.
Right. Okay. Thank you.
Whole farm portfolio.
Yeah, we've got another question, probably for Jonathan, this one. I'm interested in how best to set up a limited company alongside or within a partnership as part of a diversification strategy. Is that sort of structural thing, sort of thing that you would deal with, Jonathan?
Thank you, Susie. Yes, it is. I mean, it's a very subjective question. In terms of, there are two elements to this. One is the sort of the practicalities of it. How do you go about it? In terms of setting up a partnerships or you could, all three of us could start a partnership tomorrow for a new business if we wanted. All four of us, it'd be great. We do marvelously, and we under the Partnership Act 1890, and we crack on and do what we do. It doesn't have to be written down. It should be. As a lawyer, I would say write everything down, wouldn't I? But you can have a partnership deed, which is important, and lawyers can set that up. Or in terms of perhaps more sophisticated businesses, you could have a limited liability partnership. Again, that should be written down and incorporated at Companies House. Or if you're going to actually have a limited company, that needs to be dealt with at Companies House. It begins to get a lot more complicated because you're then thinking about yearly reports and returns to Companies House and accounts and just managing the statutory obligations of the company. And so in terms of practically, there are what's called shell companies. You can go and buy a shell company relatively quickly. And there are businesses that do that, accountants do them, lawyers do them. That's the first bit. The second bit is, what's right for you? Well, gosh, that really depends on your business and your structure. And as Susie said, it comes down to the structure of your business and your family business and what's right for you and how it fits in tax-wise. And it maybe you want to completely ring fence that business, so if it God forbid fails, it doesn't affect the rest of the business. Or maybe that you're starting off, you're entrepreneurial, it's a small entity along with a small entity, and you just want to combine the two together. It really is going to be a question of what your structure is at the moment and how you see it going forward. And all businesses evolve, and they evolve into different structures and entities as they go forward. And that's very much dependent on what's happening with the business, who's involved in it, the income, and the tax. So yeah, very subjective, but again, it's a matter of tailoring it to what is right. But anything, well, within the structure of the business entity's profit under English law is possible. Susie.
Thank you. I think that probably answers another question, which is really just a general question about what's the best way to structure a diversified business if two generations are involved. Is it better to do it away from the farming business? And again, it's going to depend on what your existing structure is and what the proposition is for the diversified business, I guess.
Yeah, very much so. I acted for an estate where they had a very successful drinks business as well, completely separate to the rest of the estate. But when we had estate meetings, went sequentially through the different businesses, now they contributed to the life of the estate, but very separate. Both because completely separate businesses, running the estate and running a drinks business, separate things didn't necessarily happen on separate sites while the drinks business was on the estate, but they kept them very much apart. And that was partly because different generations were running different parts of the business. And it was felt that was the right way to do it for that reason, as much as any tax or other issue. Okay,
thank you. Nicola, one for you, just because of your planning experience.
Susie, can I jump in there just to add something on partnerships and structures, just because it's an interesting side spin-off from that. But in setting up all these structures, and you might have limited companies and partnerships and trustees and then individuals, for each of them, you don't necessarily have to have a different policy for every entity. And actually, it's quite often we quite often see where you have a farm policy where it's just the individual noted as the policy holder, but actually some of the kit might be owned by the partnership, the revenue might be owned by a limited company, and actually get all those names down on the policy holder title, so you're not exposed to someone being not covered, if you know what I mean. But then beyond that, as Jonathan said, you've got a drinks business on one side and you've got a farming operation on the other. If they are totally separate, you can have two separate policies for it, obviously. And in doing so, you just need to be really clear that there's no gap in the middle where covers could get missed off. But it's a point to pick up. But actually, you don't have to have a separate policy for every different entity. You can have them on one and have this overarching cover in liability, if you like, for everyone. And you can break it off where you feel it necessary, where they are totally separate and run totally separate and totally separate risks.
Okay, thank you, Freddie. Yeah. Yeah, planning one for Nicola. This person started the process of getting planning consent to convert redundant grain stores to light industrial units a year ago. I know with COVID, the planning process doesn't always go as quickly as we want it to, even before COVID, but I know things have ground much more slowly since. They can't understand why it's taking so long, and they're worried they'll have missed the boat by the time they actually come to start to market the space. What is demand like? I mean, it's probably not. If you comment on the planning, why it's taking so long to get planning in the first place, and then perhaps on your experience of the market and the demand for light industrial uses.
Thank you. So, yeah, planning has been majorly held up by COVID, and it's understandable. Everyone had to get used to a new way of working, and many, unfortunately, local authorities weren't set up for having all their staff working from home. So understandably, it meant that there were time delays in terms of processing applications. At the moment, there are many councils that have long validation periods. So that is when you've submitted your application. It's the time that the local authority then process it and give you a reference number and it goes live. I have heard that some local authorities have a 3-month waiting list for their validation. What I would suggest is always to submit via the planning portal rather than submit direct to the local authority, because the planning portal can all be done electronically, which has been quite good with COVID, because obviously applications that have been submitted in hard copy take longer for them to scan and put in, but also the planning portal, from an agent's perspective, we can nominate someone to pay the planning fee. So that's an electronic email goes off to whoever I've nominated to pay the fee, and then they've got a variety of options of how to pay. And I'd always recommend paying by any method but not cheque, because cheque has to go off to planning portal in Birmingham, I believe. They then have to process it. They then have to transfer that money to the local authority. So it takes a lot longer if you pay by cheque, whereas if you pay by fax, for example, or online through using your card, it's pretty much instant that then it automatically goes to the local authority and it's in their inbox waiting for the validation process to happen. Once obviously the application is validated and live, we're then having to go out to consultation. The consultation period is normally 21 days for a minor application, but parish councils had to get used to a new way of working in terms of doing remote Zoom calls. Some parishes weren't having as frequent meetings as they were previously in person. And also other consultees have had the issues of COVID, so they aren't responding within their 21 days, which is pushing everything back. Obviously, what I would always recommend is keeping in touch with your planning officer, asking for regular updates. Once you've got all the consultee responses back and gone through that consultation period, it's then obviously for the planning officer, if there's not been objections, to decide the application at delegated authority, but it may be that it then needs to go to planning committee. And again, planning committees have been previously remotely held, which has been, if you can't get onto that committee the next month, you have to wait for the following committee. So I can see how applications have run on, and we do all have to allow for the human factor of what COVID has caused everybody a huge impact. But all I would say is keep in touch with the planning officer, and if things really do continue, you'd have to look at the route of making a planning appeal for non-determination. However, planning appeals are taking a very long time as well, so it may be best to persevere with the local authority and speak with your local ward member. If you can speak with your local ward member, they can help apply pressure to the local authority to process that application a bit quicker. In terms of this light industrial demand, is not particularly my field, but obviously COVID has shown that it impacts on the distribution across the country and worldwide. So there has been strong demand for it, and I can't see at the moment, with Brexit and all the rest of it, that demand's going to massively drop in the short to medium term.
That's great. Thanks very much. Yeah, one for Freddie now. Just in terms of, you mentioned in your last answer about making sure nothing falls between two parts of the business, in terms of risk. But when you're letting and diversifying, we've got a question on who's responsible for insurance. So I'm thinking, we don't have any detail, but thinking probably, in terms of letting of buildings and facilities, where you've got a third party on the site. Are there any areas that are often misunderstood, or one person, one party thinks the other party is covering that risk?
Yeah, sure. I'll answer it with two examples, if you like. One is around material damage, so something physical that you're insuring, like a building or machinery or kit or whatever it might be. And in that situation, you've got to think about who has the asset to lose. So you might think it's a great idea to say, actually, I've let this building to a tenant, I own it, but actually they're doing everything with it. It's their responsibility. They can take the cost of insuring it. But ultimately, if the worst was to happen and you were to lose that asset, lose that building, and their insurance wasn't good enough, it's not them that's lost their asset. It's you. It's you as the owner of the building that's lost your asset, and it's up to you to replace it. So, in terms of buildings, I'd always say try and insure your own one, and it's often a case one to consider when you're doing construction work, because quite often when you start building stuff or amending or doing renovation works to cottages or to farm buildings or new builds, your existing insurer won't pick up the liability for the actual construction phase, and often they'll say, well, the builder's got their own insurance. But again, if the builder hasn't got their own sufficient insurance and they get it wrong and they go bust, ultimately there's nowhere for you to turn to reclaim that back. So my advice on how to do that is to insure it yourself, and if you really are worried about the cost of it, recharge it to a tenant or a third party. The other thing to consider in terms of who's responsible is an operational risk, if you like. And if you've got tenants doing things like I saw on a couple of slides could pop up on things like motocross or sawmills or whatever it might be, dog walking facilities. We had some activity farms as well. If those aren't risks that you're operating, make sure it's not your risk to pick up in terms of liability as well. And that comes back to checking that they've got the right insurance and with the right sort of people. And if they're, I suppose another one to consider is if it's a building, a long line of buildings, try not to make the middle person insure with someone different to you, because if something materializes in the middle property and it spans out to everybody else, you then get in this horrible situation where it's whose insurance pays. So if you're all with the same people, it makes it much easier too in that regard as well. But it's essentially considering who has the asset to lose and who's at risk if something goes wrong in determining who's responsible for insuring.
Thank you. We've got a question just come in about, and hopefully it's a brief one because I want to get one to Jonathan in a minute. What animals are classified as non-agricultural or equestrian and therefore require a change of use permission to keep them on the land?
I reckon that's me. So the definition under the Town and Country Planning Act for agriculture is including horticulture, fruit growing, seed growing, dairy farming, the breeding and keeping of livestock, including any creature kept for the production of food, wool, skins, fur, or for the purpose of its use in the farming of the land. So that's quite broad ranging, and unfortunately there isn't really a completely black and white answer to the question, because, for example, your Class Q permitted development rights, which allow agricultural buildings to go to residential dwellings, it has been made very clear that equestrian or horses does not count under agricultural buildings. Whereas on farmland, if a horse grazes farmland, it's often considered that is considered livestock, in the term of the same as a cow would go out and graze in a field. But if you were to have jumps or dressage markers or anything like that in the field, that is when it goes over to being equestrian, and you would then need to change the use of that land to an equestrian use rather than agriculture. But it's been my understanding that if a horse is grazing in a field, it's the same because it's deemed as livestock. It's when you do those other ancillary things alongside it. But the use of a building, if it's stabling a horse, it is not agriculture. But if it's housing livestock in terms of bullocks or sheep or whatever, then that is deemed as agriculture.
Okay, great, thank you. Jonathan, you touched in your talk at the beginning of the webinar on possibility of more joint ventures perhaps between landlords and tenants. Now, I'm not thinking necessarily landlords and their farming tenants, but perhaps farmers and their tenants also on, in whether it's workshops or any sort of business that you've let to. Have you come across any sort of new ways of working where that the business is shared in any way between two parties that would normally simply be a landlord and tenant relationship?
Yes, Susie, thank you. I have. I mean, there's two things spring to mind where I have recently, in the last year, been involved with a limited liability partnership, which is effectively between two businesses, which is interesting. And there were two characters who had previously been landlord and tenant, and a landlord and tenant relationship existed elsewhere. But in relation to a new proposed business, it was felt that that was the right thing to do, and that was as much for a way of working and being entrepreneurial as much as any legal or tax reason, which is really interesting, because that's really how it should be, because it should be about what you think you can work at and aim together, and that's the key thing. And another one I have dealt with in the past is perhaps more what we might think about in terms of share farming agreements. I know it's not farming, but it could be where you have two businesses coming all together, and there is really comes down to a sort of a technical point in the Partnership Act about what is the partnership and what isn't in terms of sharing profits, and that's the key thing. So yes, there are ways to do it. It's very much, again, it's very subjective. It depends on what works best for that business and those individuals.
Mm-hmm. Well, one thing that was brought to our attention recently was the issue of inheritance tax reliefs, and where you have a diversified business or an estate where the rental income is getting almost to the point where it's more than the farming income, and that might risk some reliefs. And there was a suggestion that it might be a good idea for the landlord to take a share in some of the businesses that they were letting to, in order to reduce that potential tax liability. I don't know if you've come across anything of that sort.
I have to say that's sort of beyond my expertise in terms of that technical tax. But yes, again, I've come across in my time different structures, again, which are completely tax driven because of one party and what suits them best. And it might come down to, for example, land being charged, and it needs to be structured in a certain way. So yes.
Question for Freddie. Rebuild costs have gone up due to the issue of raw material prices having risen, and we all know can't get drivers to deliver things at the moment, so I guess that's a factor as well. Should people be reassessing a building's insured value, and if its rebuild cost has gone up because of the materials issue, will they have to pay higher premiums? Freddie?
Yeah, it's good. A good question. It's a pertinent point to this year alone. In any year, getting your sums insured right is absolutely essential. I don't want to open up the topic of underinsurance because it's a whole webinar in itself, but getting them right and being comfortable with what level they are is absolutely essential. In terms of where they go to each year, your insurer will usually propose what we call index linking, and that's an allowance for how much building costs have gone on each year. They're not mandatory for you to take. If you decide that actually they're unrealistic and you don't need to increase it that much, you don't have to take it up, move them on. But they are designed to keep the sum insured that you have originally, perhaps when you last did evaluation, moving on in line with where rebuild costs have gone. And in the last 12 months or last 18 months, absolutely, supply chains have been really squeezed, and the cost of building has gone up substantially. And we're just starting to see those index linking figures drop back to closer to where they were pre-pandemic. But yeah, absolutely, checking your sums insured and keeping them accurate in any year of all years this year is key.
Okay, so would that index linking that you mentioned, would that cover a rise that's sort of bigger than usual as we've seen over the last few months, or is it a standard?
It's a standard figure given across the country, but it's relevant to that year. So it has been adjusted this year, as I say, for the supply chains being affected and the cost of building going up. absolutely, that has a change this year, and it's allowed for that. And that's what I'm saying. Actually, this year there have been abnormally large increases as a reflection of those increased costs.
Yeah.
And as I say, they're not mandatory to take, but they are always recommended to keep it moving on as it should do.
So the final bit of that question was, and do premiums rise as a result of that, I presume?
Yeah, so that's a whole other topic again. That we've entered a hardening market for the first time in about 10 or 15 years. But again, I could talk to you for hours about that, and I'd love to. But if your sum insured is higher, you'll pay more premium. It is not the place to save money in moving your sums insured down. Make sure they're spot on. In fact, there's a good general point in my two key bits to be aware of is make sure your public liability and your employer's liability is at the right level, because that's your biggest exposure. That's the one that could really cripple you if it goes wrong. And the other is to get your sums insured right. Getting them right from the start is going to serve you much better in the long run than it is by trying to get away with saying, actually, that's about right. It's not quite enough, but it's about right, because that will sting you later on.
If you have a claim, thank you.
There are other ways to save.
Yeah, thank you. Right, we hear a lot about permitted development rights, and this is one for Nicola. It might have to be our last question, but I guess it might be a fairly short answer, so we might squeeze another one in. Can I open a pop-up cake stall or cafe for a limited number of days a year without planning permission to test the water?
Thanks, Susie. So if you're going to do your pop-up cake stall in like a gazebo or outside, you can up to 28 days change the use of a piece of land. So, for example, I'm sure many of you have heard that normally you can do a 28-day pop-up campsite, which this year got extended to 56, but it was only for that reason. Whereas for a cake stall or anything like that, you could do it for 28 days, but it's only on land, so you wouldn't be able to be in a building to change the use of the building. It's purely based on land. So if it's going to be wet, I would suggest the gazebo, but otherwise, have a table and then see how it goes.
Right, thank you very much. Let's look for another question. This is another planning one. We have got quite a lot of planning ones. Secure dog walking field planning application is current with the local authority. It's been approved by the case officer, but lots of resistance at the local level, as there's been a rumour spread that this will give the land raised planning status and lead to residential planning, which is not the plan. So the parish council is against it, so is the local councillor. It has to go to the planning board, which I presume they mean the committee, to decide its fate. Is there any specific planning policy that supports such a change of use application and general diversification for fields that will become redundant due to the farming practice being downscaled?
Thank you. I suppose in the first instance, I'm not sure a field is going to become redundant. I'm sure if you weren't going to use it for agriculture, someone else would use it for agriculture. It's not quite like a building that would become redundant. Agricultural land will still have a use of some form. Obviously, I don't know where you're from, so I don't know what local authorities' policies you've got, but under the National Planning Policy Framework, paragraph 84, which details supporting a prosperous rural economy, there is a clause in there about diversification, which would be a good starting point. It is unlikely they're going to have a policy specifically on dog walking. I haven't seen one yet personally, but the angles that I was looking at were obviously COVID has caused a boom in dogs' popularity, basically, and the value of dogs have gone up as a result. And a lot of households now have a dog. Alongside that, COVID has also caused that some of the dog training classes and things like that haven't been available because of COVID. So what I was looking at personally were statistics from the local police in terms of dog thefts, but also in terms of dog attacks on livestock using public rights of way, because unfortunately some people don't have the good enough control of their dogs. That unfortunately causes incidences. And I use that as part of my argument that actually having a secure field with high fencing, people were able to go there and A, themselves feel safe, but also B, knowing that dog is not going to get free. And we also interacted on ours about we're going to advertise classes to get people to train their dogs. And basically a lot of that comes off the back of the dog boom due to COVID.
Right, interesting. Thank you. Yes, COVID's changed lots of things, and I think for some people who already had successful diversifications, some of them have had to adapt during COVID, and a lot of them are planning to keep many of the changes that they were almost forced to make to keep the diversifications going. So it's been quite a challenging but interesting process for people. Well, I think we're just about on the end of our time. Thank you all very much for your time and expertise. And we've got through almost all the questions, so that's good going. Not quite all of them. Thank you all very much. And I hope that it's given people lots of food for thought and keep them on the right track in some respects that they may not otherwise have known about. Thank you.